You believe your doctor screwed up big time, causing you significant harm and injury, and now you want to sue him. But you've heard that it takes 2 to 3 years from the time you start a case until you get all the way to trial. Can you go into court and buy a speed pass that will allow you to bypass the lines and get your case quicker to trial, faster than everybody else? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, no, there isn't. It's not like Disney World where you can get a speed pass, bypass the lines, or come back a couple of hours later and go right to the front of the line. It doesn't work that way. None of it works that way. So how does it work, and why does it take so long to get your case, your medical malpractice case, all the way to trial? Well, let me give you an idea to answer that particular question. So now you believe your doctor was careless and caused you significant harm and injury. And now, in order to know whether or not you have a valid case, you have to go to an attorney who then obtains all of your medical records. A really good attorney is then going to go through each and every page of your medical record so that he becomes familiar with every single aspect of your case. Then he's got to hire a qualified, board-certified medical expert to go ahead and review all of your medical records. Once the medical expert has reviewed those records, he has to really determine, number one, was your doctor careless? Number two, was that carelessness a cause of your injury? And number three, are your injuries really significant and or permanent? If the answer is yes to all three of those things, now we have the ability to go forward and file a lawsuit on your behalf. So now you're wondering, okay, why does it take so long to actually get to trial? Why can't we just get that speed pass, file the documents, and go ahead and go right to trial? Well, in an ideal world, that would be exactly what we would want to happen. Here's the reality. Once we actually start a lawsuit, we are in the discovery phase because the doctor and the attorney who represents the doctor, they are behind the curve, meaning that they have not had an opportunity to, number one, get your medical records, number two, speak to a medical expert or multiple medical experts to evaluate your case, to evaluate whether their client, the doctor, violated the standard of care, and whether or not those violations, that carelessness, was a cause of your injury. And then they have not had an opportunity to go ahead and evaluate the current extent of your injuries. All of that takes time. And during the course of this discovery phase, where each side has an opportunity to obtain medical records from the other side and to question the witnesses and the parties who are involved in the case, now that takes a significant amount of time. The attorneys also have to appear in court from time to let the judge who's supervising your case to know exactly what's going on. And you should also know that there are oftentimes disputes that arise amongst the attorneys, the attorney for the doctor and the attorney for you. And what kind of disputes? Discovery disputes. Hey, give us tax returns. No, you can't have tax returns. Hey, give us medical records that go back 20 years. Hey, not a chance. You're only entitled to get medical records for the past 3 years. And now disputes arise, and because the attorneys cannot resolve this issue, now they have to go in front of the judge and ask the judge to intervene and make a decision. And you would think that attorneys who have been doing this for a long time know exactly what they are entitled to and know what they're not entitled to. I'll give you a better example. What happens if the defense comes to us and says, hey, we want access to your client's Facebook page and everything that's marked private? Can we just go ahead and unlock it and give it to them? The answer is maybe yes, and then again, maybe no. There is specific case law about whether or not we can or whether or not the defense can actually request this. So there are disputes that will arise during the course of the litigation. You should also know that after the discovery period is over, where now everybody has gotten all the materials, all the documents, all the exhibits necessary to actually evaluate the case, now the defense is going to turn around and ask the judge to throw out your case, and now your attorney has to oppose that. And again, you've got a fight going on because the defense is going to fight us every step of the way. And because of that, that means delays. If they didn't oppose anything, if they didn't fight with us, sure, now we can move things along really quickly. And now when we scheduled things to get done, like, hey, we need your client to show up for a deposition, a pretrial question and answer session. If we could get those done right away, you know what? Now it would short circuit everything, and instead of 2 to 3 years, guess what? Now it's a much shorter time period. But here's something else that we have no control about, and this is probably one of the most frustrating things. After the discovery period is over, now we have to notify the court that your case is actually ready for trial. Now we file some documents with the court that really says, hey, we just want to let you know we finished the discovery phase and now we are ready for trial. Well, that's very interesting because you know what the court really says? They says, that's nice, take a number. That's exactly what happens. The documents that we file go down to the bottom of the pile. And now there's a huge backlog depending upon which county we are in. It's Brooklyn, it's Bronx, it's Queens, Manhattan, or some other county. And now we have to wait our turn for all the cases that came ahead of us to go ahead and get their cases resolved. Now, why is that a big deal? Because there is a significant backlog in almost every county in New York. In some counties, it can take 6 to 9 to 12 months or even more from the time we notify the court that we're ready for trial until we actually get called in for a pretrial conference or for scheduling jury selection. So all this time goes on and nothing is happening on your case. And you're sitting and you're waiting and waiting, wondering why. Why can't I just get a speed pass, go to the front of the line? Because that's not how it works. That's not how any of it works. I wish it did. So why do I share this great information with you? I share it with you just to give you an insight of exactly what happens if you're contemplating bringing a lawsuit here in the state of New York. So my suggestion is if you do have questions and want to buy a speed pass, no, there is no speed pass. But if you do have questions and you have not yet started a lawsuit and your matter did happen here in New York, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.